Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. Today's Legally Speaking seminar is about green card or status of lawful permanent resident based on marriage. A green card holder or a U.S. citizen may sponsor their spouse to the United States. If the person who you're going to sponsor is overseas, you will need to go through a consular processing. If the person who you would like to sponsor is in the United States, you will go through something called adjustment of status in the United States. Let's say first scenario. One of the spouses is a U.S. citizen and his or her spouse is in the United States. If the non-citizen entered the country legally, was paroled or admitted and inspected at the border, regardless of the length of the time the non-citizen spent illegally in the United States, his spouse, a U.S. citizen spouse, will be able to fix their immigration status with the I-130 petition and adjustment of status package. If the spouse of a U.S. citizen entered the country without inspection, the U.S. citizen still can help the non-citizen spouse to become legal in the United States. But it's likely that the non-citizen will need a waiver. And there are different waivers available. It can be I-601A waiver if the only problem that the non-citizen may have is the illegal entry, or it can be I-601 waiver, which is a less desirable waiver because this waiver can be filed and only when the person is overseas, and the result has to be the person who is a non-citizen will have to wait for the result of the waiver when the person is outside of the country. So I-601A waiver, which you can read more about on our website www.shautsova.com, is more desirable option. If a U.S. citizen would like to sponsor their spouse who are outside of the country, the process would start with the same I-130 petition. Once the petition is approved, the approval will be sent to the National Visa Center, which acts as a middleman between the citizen and non-citizen and consulate. All the supporting documents for the immigrant visa petition will be sent to the National Visa Center, which will sort the documents and inform overseas consulate when the person is ready to appear for an interview. Once the interviews pass successfully, the non-citizen will receive a visa. Depending on how long the marriage to a citizen is, if it's longer than 2 years at the time of the interview, the visa will be an immigrant visa, and once non-citizen enters the United States, he or she will receive a permanent or a 10-year green card. If the marriage to a citizen at the time of the interview is less than 2 years old, the non-citizen will receive a conditional resident status and will still have to apply for removal of the condition during the 90 days before the second anniversary of the holding of the conditional resident status. I hope it makes some sense what I just said, because I know it's very hard to understand all the regulations. And that is why on our website there are short blogs dedicated to each specific step in this process. Let's say that a person who is sponsoring a spouse is not a citizen, but only a lawful permanent resident. What is the difference? Well, first of all, if it's a lawful permanent resident who's sponsoring their spouse who's currently in the United States, the non-citizen, non-lawful permanent resident is in the United States, and if that person is in illegal status or does not have a status, let's say the status expired or the person never had a status because entered the country illegally, the non-citizen or non-green card holder will still need a waiver. So unlike with a citizen, the person who is in the United States, who entered the country legally and later his or her status expired, will need a waiver and will have to leave the country as well. It's not going to be possible to adjust the status in the United States. If the spouse is overseas, it will be considerably longer to sponsor them, opposed to when the petitioner is a U.S. citizen, because there is something now comes to play which is called a priority date. When it's not a U.S. citizen but a lawful permanent resident who is sponsoring their spouse who is overseas, then there is a priority date which has to become current before the person who is overseas can apply for a visa, and it takes about 2 years longer than when the person is a U.S. citizen. Let's say a permanent resident started the process, but during the process he or she became a citizen, and now the wait time for the non-citizen should be shortened. How does it work? Well, the petition, the I-130 petition that a green card holder filed, will be upgraded automatically to a petition by a citizen. So you really don't have to do anything. USCIS will do upgrade for you. So this is the only difference, but it can be a significant difference because of the wait time and necessity of the waiver, opposed not have to have a waiver if your spouse is a U.S. citizen and you are in the United States. Of course, whatever the process is, the spouses will have to present USCIS with the evidence of a legal and real marriage. There have to be a marriage certificate. There have to be certificates of divorce or judgments of divorce for all prior marriages. Do not assume that just because you've been married multiple times and you were allowed to marry a second and third person, you don't have to present certificates of divorce for the first and second spouse. You have to present certificates of divorce for all prior marriages. Certificate of marriage, certificate of divorce, documents showing that you have funds in common, let's say statements from joint bank accounts. If you don't have that, maybe you purchased something together, maybe you traveled somewhere together. Of course, the best evidence if you have children together. You also can present affidavits by friends or family, people who know you and who are U.S. citizens or permanent residents, who can testify that your marriage is real according to their knowledge. So that helps. And during the second portion of the sponsorship, when the person is establishing his or her eligibility for a green card, the person will have to show why they're eligible for a green card, or that they're not ineligible for a green card, that they don't have convictions that would disqualify them from the green card, that there is a sponsor, in whether it's a U.S. citizen or a green card holder. The petitioner has to show that he or she has sufficient income to sponsor somebody in the United States. And if that person does not have sufficient income, they have to find a joint sponsor who does have sufficient income. But this is usually done if the person who is sponsoring is overseas. This will be done at the NVC stage. And there are many different, I receive many different questions about the income. What if last year my income was 0 and this year it's 100,000? Can I still sponsor somebody? Yes, you can. It's a current income that matters. If in previous years you did not make any money, but today you're making sufficient money, you still can sponsor somebody. If last year you made a lot of money, but this year you don't make any money, well, you can use your assets. If you have it, if you don't, you will have to find a joint sponsor. Because the first evidence that USCIS is looking at when they determine sufficiency of the income is your tax returns and your W-2 statements and your pay stubs to see if you have enough money. So that's how it works. Children. Very often I receive a question, I'm going to marry somebody with children. Can I sponsor those children? Can I include them in the same petition? You cannot. Every person who you sponsor on the I-130 petition, you will have to file a separate petition for the dependents. In dependents, we talk about children who are at the time of marriage were under 18. Those are the children that you can sponsor. If the kid was 19 at the time of the marriage, unfortunately, you will not be able to sponsor them. their parent will have to sponsor them once the parent gets the green card. So I hope this video was a little bit helpful in understanding the process of the green card based on marriage and overseas procedure. You can read more about this in our marriage visas section on the website www.shautsova.com. Thank you.